it's not satisfied on the outcome of the election as declared by the EC, has the right to go to court to challenge the election, which is taken from Article 64.
All right.
Now, pursuant to that, we have Parliament passing CI 74, which is a law which takes its validity from the Constitution. Now, CI 74 sets out the parameters which should be followed by a person challenging the petition.
All right.
So it states out who can challenge. The person must be a Ghanaian. What he should show how he became a Ghanaian, what his challenge is, and what he wants the court to do, which I believe the petitioners have done.
All right.
The law also says that a person whose election is challenged becomes a respondent. So that is how Mr. John Mahama becomes a respondent. Because there was some confusion in the people's minds as to whether or not the president can be sued. Now, that confusion has a basis. But if you look at NPP versus the Attorney General and Rawlings, the court said that the president in his functions cannot be sued.
All right.
He has what they call immunity.
All right.
Now, that immunity is limited to his person, but his actions can be challenged in the name of the Attorney General.
Okay.
So once the president makes pronouncements, whatever pronouncements he makes which are not in sync with the Constitution, any person can bring an action to challenge that action. However, that action must be in the name of the Attorney General.
All right.
So that is what caused the confusion. But CI 74 specifically says that if a person's election is challenged, that person must be a respondent. And the Electoral Commission, if the person complains about the conduct of the Electoral Commission. So the laws have set the patterns that we must follow.
Okay.
But before I proceed, I need to make it clear that the Constitution, where all these powers are drawn from, says that once a person is declared by the Electoral Commission as having won the election, that person is president. And until the Supreme Court makes a declaration to the effect, to the contrary, that person is president.
All right.
And whatever he has done up to that point shall not be invalidated.
Okay.
So my first plea will be that Mr. John Mahama, prima facie, has been elected as president of Ghana as declared by the EC, has been sworn in. So Ghana has a president.
He's vested with all the power,
all the authority
to do everything that the president is required to do, an executive president at that.
It is my prayer that every person must give him the support and the prayer for him to carve out his vision. Because the point is, when a person brings a petition, the law itself makes provision for the withdrawal of the petition.
All right.
And if, as I hear some people calling him caretaker president, it is wrong. The person is president.
All right.
We give him all the support until such time that the Supreme Court, drawing its powers from the Constitution, makes a declaration to the contrary.
Okay. Now, and you also made reference to this being this presidential election petition or challenge being the first of its kind. But there's reference that's been made to Rojo Metal Nunu and the Electoral Commission, where Rojo Metal Nunu and some other individuals in the NDC also sought to challenge, you know, the validity of the election of President Kufuor. All right. So just that out of the way, I want to find out from you already. We'll get into some of the fine details about the various procedures and processes, but there's already talk that for as long as the matter remains with the court, the Supreme Court, it is wrong for anybody to run any commentary about it. Is that the position of the law?
Well, the Ghana Bar Association, taking inspiration from Section 8 of its Code of Ethics, says that a person who has been instructed as counsel in a matter ought not grant an interview to a member of the press in a matter in which he has been instructed.
All right.
Now, you see, there's a way of going around this by saying that, okay, I have been instructed. So, Samson, go and say A, B, C, D, because you have not been instructed. That is what Section 8 says.
All right.
So in view of that, resolution upon resolution, and I can start from 2006 to 2011, we've consistently at the annual conference been talking about media trial of matters, that lawyers must desist from media trial. Because you see, if you look at the code of ethics, we have a disciplinary procedure, but somebody says that it can't bite because it is the General Legal Council which regulates the practice.
That is so.
Under the Constitution, the Bar Association is a voluntary association. Therefore, we admonish ourselves and charge ourselves that we shall not discuss matters in the media. Because, unfortunately, what it does, it puts unnecessary pressure on the judges. Because
we've had the judge yesterday issuing a rebuttal or explanation to something he heard on radio, and he quoted news file that he had heard that somebody suggested on the program that he had been a regional chairman of the NPP before, and so there was also the likelihood that he would not be fair in the matter.
Yes.
Yesterday, when the joint application came up for hearing, he made it clear in the court that the person had his facts wrong and that he has never been chairman of the NPP or a member, in that respect. So they also listen, they feed in on what goes on in the public.
Samson, I'll take a leaf from what Honorable Inusa Fuseni said on Metro TV's Good Morning today, that when these statements are made about judges, no one can sympathize with the judges or feel their pain as much as the judges themselves. And I thought it was such a profound statement because, you see, we may sympathize with them that, oh, well, the comment was not right, but how they feel, because they have families. And I always make this example that when I was in class 2, my father was made the guest of honor in my primary school, and my mother dished out the prizes, and I had 3 prizes. And the things they said about my father when I was in class 2, I then decided that I also wanted to be a lawyer. Because they were so complimentary, I said, oh, if that is how my father is, then I also want to be a lawyer.
Okay.
Now, the reverse is that the same judge's child who hears such uncomplimentary things said about her or his father may cringe from the judicial service and say, hey, I don't want to be like my father. But her father may be a very competent judge. So these statements that we make, we must be extremely circumspect.
All right. But it's also important to note that this matter is such an important, issue in court, the presidential election petition. And it borders on the stability of the country itself. We can't have all the people who voted, close to how many, 13,000 plus. We can't have all of them go to the courts and be part of the process. You need a certain flow of information so that they can be part of the entire process where they are supposed to exercise restraint. They would get that information. So it is important to make a certain difference between commenting on ordinary matters and also commenting on a matter as important as this one.
Yes, you are perfectly right. Now, yesterday in the morning, there was a reporter from Peace FM who reported what was happening in the court. He stated the fact of the petition, the fact of the answer by the EC. And I sent a text to the host that this is perfect. They just stated the facts as to what the petitioner is asking the court to do, what the respondent has said about the petition, and what the EC had said. And that is good public education because the public gets to know that this is what the petitioner is asking for, this is what the respondent is saying, and you leave it to the court.
The lawyers can do the same, can't they?
They can. They can. But of course, if you look at the ethics, a lawyer who is instructed as counsel should not.
All right.
Lawyers can do the same in terms of public education. And I fully commend that. Indeed, the Ghana Bar Association said that lawyers must comment on public and national issues. The Bar Association also further said that lawyers can engage in active politics. But the Bar Association as an association will desist from entering into the fray of politics because you realize that the politics is so polarized. Now, for example, my position as public relations officer, I represent everybody, including you, and they have different shades of opinion. Some are PNC, some are NDC.
All right.
So how can I be seen to be representing the MPP or the NDC for that matter? I say what lawyers ought to say and leave it at that, and give the decision of the matters to the courts.
I see.
And that is all we are asking, that lawyers must be the forefront of educating people as to what is happening. For example, I said, and lawyers should say, that there need not be any panic because the Constitution has made provision for it. We have engaged ourselves to be ruled by law. Therefore, I think that Ghana has come a long way. It is only unfortunate that sometimes some hitches occur in terms of the supporters misappreciating what is happening. But left to me alone, no supporter should venture to the Supreme Court, because the business is the business of lawyers and the judges.
Well, before we get into the procedure proper, again, I'll ask this. This is about lawyers or the public running commentary about the matters that are pending in court. And you are saying that the public has the right to know the facts.
The facts.
But if journalists are running commentary about the matters, they cannot speak. They cannot attempt to comment on the merits of the matter. Okay. And then lawyers who are not directly engaged or instructed by clients to handle those matters can also help in the process of public education. Is it wrong for, and the Ghana Bar Association has issued a statement asking both legal representation of the petitioners and the respondents to follow the ethics of the profession. Is it wrong for the legal team of the petitioners and the respondents as well to choose from among the members someone to be speaking for them? Is it wrong? Because they have done so.
Technically.
They have done so.
From the ethics
for the
of the
NDC team, it is Nana Atudazi who has been officially designated to engage with the media. For the petitioners, Nana Akufo-Addo and co., it is Gloria Akufu who has been designated to speak for the team.
Now, if you juxtapose that with the ethics, the question that you ask is, has that person been instructed as counsel in the matter? If he has, then he's breaching the rules of ethics. But I believe that maybe persons who have not been instructed as counsel in the matter, who are lawyers, could be designated to handle press matters. Now, I always take a leaf from Sky News. When they get out of the court, you see that the lawyers make brief statements. They just say what happened in court. We took this application to the court. The court said X, Y, Z. Whether they intend to appeal, whether it was wrong or right, they just leave it at that and tell the public the bare facts. As to what they intend to do as lawyers when they get to their chambers and they take instructions, they will do it. You know, I said that someone was saying that we should try and break it down as much as possible. But law, as you know, is a fine art. You get to a point, you can't break it down further. That is why I said,
all right, and I'm sure that some of you who are watching at this moment are having a difficulty appreciating properly the whole of the discussion. But I am doing my best to ensure that we try and, you know, bring it down. And I think that Tony Forsing is also doing his best in doing it in that manner. You're on PM Express here on your multi-TV's Joy News channel. Your text messages are welcome, 1760. You can also post your comment on our Facebook wall. If you have questions for him, let me know and I'll ask him and he will respond to them. And I want us to stick to election petitions. It should not be limited only to the presidential election petition. We have petitions that are pending in the High Court in respect of parliamentary elections, and he would educate us about that also. We'll take a quick break. We'll be right back. Welcome back, and this is PM Express on your Joy News channel on Multi-TV. I am Samson Ladia Yenini. I'm sitting in for your regular host, Stephen Enti. My guest of the studio is Tony Forsing. He is the National Public Relations Officer of the Ghana Bar Association, and we are doing a discussion trying to help educate you on the election, petitions or election-related disputes and how they are resolved by the courts. Now, we have heard people use terms like petition, rates, or case or matter. When it comes to elections, what is the proper legal terminology to use?
Well, with elections, the proper mode of putting your case before a court is called a petition. Now, as to the difference between a petition, a writ, etc., these are terms of art.
But at the same time, you have the PNC's General Secretary, Bernard Mona, who is also in court over these same election matters, particularly challenging the portions of the constitutionality of portions of CI 74. That is the Supreme Court rules. Now, his own is being referred to as a writ. Why is it that his own is being referred to as a writ and what Nanado and co have taken to the court is referred to as a petition?
Well, that is the requirement of the law. Now, the jurisdiction of the Supreme Court as defined in the Constitution, when I used to teach, I had a simple way of teaching it. I said it's OSARP, OSARP, original jurisdiction, supervisory jurisdiction, appellate jurisdiction, review jurisdiction, and the production of official documents.
All right.
OSARP. Now, in Bernard Mona's case, he's invoking what they call the original jurisdiction of the court to make a determination that a constitutional instrument under Article 2.1, to the extent of its inconsistency, is null and void. So he has to come by writ to invoke the original jurisdiction of the court. With what Nana Akufo-Addo and co have done, it's an election petition as defined in Article 63, that a person who is challenging the outcome of an election should present a petition to the Supreme Court. Now, flowing from that, you have what they call CI 74, which shows you what should go into the petition, the contents.
So there is no one way to commence, to commence a matter, or I don't know how to put it simply for you, at the Supreme Court. There are a number of ways. You can go by a rate.
You are seeking the Supreme Court to do for you. For example, the production of official documents.
All right.
It is the Supreme Court which has that power. So it depends on what you are asking from the Supreme Court. Then you go back to the law to seek what way you should produce it. Now, in furtherance of that, the Judicial Service of Ghana produced this manual. Now, some have questioned that why is this manual being shown now? Now, before the Ghana Bar Association conference, I was in this same studio. And I showed this manual and thanked the Judicial Service for making it available for all lawyers. This was way before the election. They did it in conjunction with DFID and gave copies to so many people. So I have urged on several platforms that since we have this manual, which encapsulates all the cases which had been adjudicated upon since 1992, in a bid to facilitate an effective and quick resolution of election disputes, the judges must be strict.
It's like a one-stop shop.
It's a manual on election
for
petitions.
all the laws and rules and cases, precedents on election petitions.
So it's a ready-made answer, so that when your client comes to you, depending on whether it is the High Court or the Supreme Court, you know exactly where to go for the law.
So if it is a presidential election that you want to challenge, you go to the Supreme Court. But if it is a parliamentary election that you have a problem with, you go to the High Court. And these are clearly set out by the rules as you have them also captured on the election manual.
That is so. Now, when it has to do with the High Court or the determination of whether or not a person has been validly elected as Speaker of Parliament, it is Article 99. Now, it is important to know that when you are talking of the rule of law, it is a commitment to be ruled by law. It is a commitment to be ruled by law, not arbitrarily. Therefore, what we are seeking to do is that people should be more aware of whatever rights they have and the fact that whoever is exercising his right, your rights on your behalf has been given that mandate by you through your vote, as what is said in the Latin, your votum. That once you have surrendered your sovereignty, that one vote to that person is accountable to you. That is why the Constitution says that the Constitution shall be the supreme law, and that the power resides in the people and is derived from that mandate that the people give to you.
Okay. Now, I'm going to play this clip, and when I come, I would want you to answer the question, what do you lawyers mean when you say this matter is sub judice or sub judice? And I'm sure we have had an earlier discussion and you have sought to throw a broader light on all of it, what you can comment on, what you cannot comment on, and so on and so forth. But let's watch this briefly, and then you respond to that question for me. What do you mean when you say the matter is sub judice?
Curiously, a judge says there, he thinks that a simple application that is being made, is bringing the whole country, on his knees. I think that it is wrong, and I do not know whether or not he was already privy to, what the counsel for the, applicants, respondents were making.
There has been talk about the breaking down of this country. That is not our intention. Indeed, it is.
All right, thank you very much. This is PM Express, and I played this earlier on. And when you watch again, are they doing what you call sub judice? What is it?
Well, this is not exactly sub judice. Sub judice, if you look at Black's Law Dictionary, it talks about a matter being under the consideration of a judge. That is what it means. Sub judice. Judice is judiciary.
Okay.
It is under the consideration of a judge.
So it's a matter pending in court.
I always use a simple example of when we put our matters before our traditional chiefs.
All right.
That is the simplest example I use. That when you put the matter before the chief's palace, a date is set.
You hold your peace.
You hold your peace. You don't go to the radio station and start talking about what Nana should do or what Nana ought not to do. We all await Nana's decision.
Okay.
And when Nana's decision comes, we either say, well, Nana's decision, in my view, was not fair or it was fair. But at least we give Nana that benefit of the doubt that let him pronounce. So I say, let us extend this courtesy to the courts.
Okay.
That once we have put the matter before the court and it is sub judice, that is, it is under the consideration of the court, let us hold our peace.
Okay.
Because we as leaders are the ones who incite or help people keep their peace.
Okay, I've got a few text messages here. Alokos in Tamale writes, we need to build stronger institutions to guide and strengthen our growing democracy. I am very optimistic about the NPP winning the case before the Supreme Court. Is it right for us to be saying you are hopeful one will win or one will lose?
I do not think there's anything wrong in saying that you are hopeful you will win. Hope and faith, these are things which are stated in the Bible that everybody should have.
Okay.
So I believe that when a person feels strongly about something and sends his matter to court, I believe he hopes that he will win.
All right.
There's nothing wrong with hoping.
Kaba Edward from Sankore writes, political leadership, lawyers and judges alike now engage in insinuations on radio, either other than dealing with the matter before them. Sorry, I'm not aware of a judge who has engaged in insinuations on radio. So that one I will be straight to tell you about that. Nanado, okay, you see, keep your discussion to what we are talking about here. This one says, peace, peace, peace. Ghana needs peace to build a nation. Political talk about what you can do for our mother Ghana, and we should stop the backbiting. All right, so I really want to read your messages, but I want them to be messages that are connected to what we are doing on the show here. Now, we are at the Supreme Court on the presidential election petition. There's a lot of attention on the Supreme Court. Some people are asking presently, the judges, you have 9 of them who are considering the joinder application, but they have read elsewhere and earlier that you have 5 judges and then you have 7 judges. What is going on?
Yes, the law says that for the ordinary dispatch of business in the Supreme Court, the court shall be constituted by 5 persons.
Not less than. Okay.
Ordinary dispatch. Now, when you come to CI 74, it talks about the ordinary dispatch being 5 judges. People have expressed their opinion that in such sensitive constitutional matters, they believe that all the judges must sit. There's a school of thought which says that to make it operable, that CI 74 says that there shall be no review, then let all the judges sit, so that once a determination is made, then it is a determination of the whole Supreme Court. So then well, some people say, I don't want to go into Bernard Bonner's matter, so that the issue of review will not come up. Well, the law as it stands says there shall be no review until such time that the Supreme Court also makes its comment on that. I leave it.
All right.
But the point is that the law says that for the ordinary dispatch in these election petitions, the court shall be constituted by not less than 5. That is what the law says.
All right.
So that is what should be done. So it could be 6, it could be 7, it could be 8, it could be all of them. But at least there must be 5.
Okay, so in its day-to-day business at the Supreme Court, you have 5 judges. But there are times where you have more than 5.
Yes.
When do we have more than 5?
In its review jurisdiction, there's an enhancement of the panel so that what decision had been given earlier, if a person thinks that there has been a miscarriage of justice or there exist some special circumstances for the decision to be reviewed, the Constitution gives the Supreme Court power to review its own decision if it finds it right to do so. So it is a matter of law. So when the ordinary dispatch of the matter of 5 comes up for review, there's an enhanced panel of 7.
Okay. So in its ordinary day-to-day business, 5 justices.
Yes.
But when it goes to review, you have 7 justices. Or more. But in an election petition, the general view is that have all the judges to sit.
Yes, that is a school of thought. That is what some people think that, I mean, let all the Supreme Court judges pronounce on the matter and there's finality.
We know in Ghana we don't have a ceiling to the Supreme Court justices.
Yes.
So when you say all the judges, what are you referring to?
All the judges who are available should make a pronouncement.
At any given time, how many justices of the Supreme Court do we have in Ghana?
No, the Constitution has a lower limit that they shall not fall below 9.
Okay.
That is the lower limit. So it could be 17, it could be 18, but it should not go below. So that is what the Constitution says, and that is what must be respected. So at any time that one person goes on retirement or for whatever reason there is a vacancy in the Supreme Court, it ought to be filled.
All right. So at this moment also, we know that the election petition was filed by the NPP sometime on the 28th of December, if I'm correct.
Yes.
And then after that, the Electoral Commission sent its response.
Yes.
We understand that after the NPP had, or Nanado, the petitioners had filed their petition,
yes,
the respondents, the Electoral Commissioner and the first respondent, John Dramani Mahama, had within 10 days to file their answers.
Yes.
They have done so.
That is so.
The expiry was Saturday last week, and that is when the president filed his.
That is so.
All this while, the expectation had been that the matter will start. And we have also heard that, according to the Chief Justice and the court system, for election disputes, the process is supposed to run very fast. But nothing appears to have really started. What's going on?
Now, it is interesting, and it is important to state that, notwithstanding CI 74, which tries to expedite matters in terms of the procedure and the time frames, all the rules of natural justice apply. All the rights of parties to make interlocutory applications apply.
What is interlocutory application?
That in the meantime, pending the determination of the matter, if something comes up, for example, the NDC found it fit to apply to join the matter because it felt it had an interest. That right cannot be denied without a determination by the court.
Okay.
So that right cannot be taken away. So that is why the NDC was given the opportunity to make that application. Now, when that application is made, it must be determined before the matter can continue.
All right.
So, notwithstanding...
And also, for example, when the NPP indicated that it intended to challenge the panel, composition of the panel, that's also an interlocutory matter.
Yes.
That ought, if they had filed it, that would have been even determined before the application.
Because that is why, when they went in, the court said, go and make a formal application. That will also take time.
All right.
So, all those rights which exist in favor of parties cannot be taken away by CI 74. What CI 74 does is to just step out of the ordinary rules of court. Of course, it was made by the Rules of Court Committee. Step out, make such rules as will give an expeditious trial. However, it cannot take away any right which the Constitution grants to a party.
But some say if you allow the parties the opportunity to raise interlocutory matters and do all of these, the lawyers will resort to the legal, technicalities and attempt to delay the process, because there is a party that feels that the longer the matter remains undetermined or unresolved, it inures to their benefits. So they will do that. In this present situation, the argument is that it is the NDC that has something to lose if the matter was determined in the favor of the NPP. So they will do everything to frustrate a speedy trial, including, for example, the NDC says it's going to call 4,800, that's the John Mahama team. So they are going to call 4,800 witnesses in court. People are saying all of this is simply to frustrate a speedy process.
Well, unfortunately, I say that we should not read such meanings into it, because if you reverse the situation, that if prima facie the Electoral Commission had made a declaration that the NPP had won the election, whatever benefits that Mr. John Dramani Mahama is enjoying now would have been enjoyed by Nana Akufo-Addo. The point is that prima facie, the votes as counted were won by Mr. John Dramani Mahama. The Constitution makes provision for what should happen. So he has taken the oath.
But there is some tension, and you need to resolve it as quick as possible to douse it.
I always say that, unfortunately, I don't see the tension, because if we have committed ourselves to the rule of law, that is what the law says we should do. And a commitment is not an easy thing. So once you have committed yourself, and luckily, his Otunfo, the Asantehene, called all the parties to
committed them to a peace pact.
And they made a declaration. If you have made that solemn declaration, it behoves on you to tell your supporters to hold their peace until such time that the law takes effect and the declaration is made one way or the other.
All right.
But until such time, we have a president.
All right, I've got some text messages here. This one says, please, the petitioners have not officially designated any person to speak for them. Just because Madam Gloria Akufu spoke for the media does not mean that. Adamu Inwa. Okay, Adamu, I am talking to you on the strength of official communication. I am not speculating. Nana Atu Dazi has been selected to lead in media communications in the NDC team. If you go to the John Mahama team, I am properly informed that lawyer Dr. Dominic Ayene has been chosen to speak to the media on matters regarding John Mahama as far as the suit is concerned. With the with the Nanado and Co., we have been officially informed that Gloria Akufu speaks for the team. This one says, Samson, your guest is a national asset, and we pray he lives long to educate us.
Amen.
By Busagri and Tamale.
Amen. Thank you.
This one says the O.G. Simpson and Timothy McVeigh cases were thoroughly discussed in the press. Why not in Ghana? We want freedom of speech. This is coming from Joe. But you understand you're talking about two different jurisdictions. What is the rationale behind the CI-74 asking for only individuals to petition and not political parties on whose platform the individuals contested the election? This is coming from Majid. You want to, respond to that?
Which one? The CI-74?
Yes. Why is it asking only individuals?
Majid, the point is that CI-74 was drafted by the Rules of Court Committee and it went to Parliament. Therefore, Majid and I, our representatives in Parliament, put out CI-74. So Majid and I are also participants through our representatives in Parliament of CI-74.
All right. In the unlikely event of the Supreme Court discovering such serious electoral malpractices allegedly perpetrated, that is what you should have said, allegedly perpetrated by the NDC, would the penalties be limited to President Mahama even when the situation calls for the proscription of his party? This is Fear Famity in Accra.
Well, I believe that we have laws in Ghana. If an act is criminal, the sanctions are there.
All right.
If it affronts the Constitution, the sanctions are there. So depending on the findings which are made, the appropriate laws will be applied.
But you are not aware of a law that will allow for the proscription of the party?
Oh, if it has breached the political party's law to the extent that proscription is the necessary punishment, then that ought to be the punishment.
All right. Thank you for that text. This one says, I initially did not understand how the Bar Association could educate us objectively, but your program is good. Ishaku, Munawara in Wa. I hope I got your name correctly. Sometimes let's just do away with the prejudices and the biases, and it helps. Hello. Could you please allow your guest to explain the difference between constitutional instrument, executive instrument, and legislative instrument? Constitutional, executive, and legislative.
Yes. The quickest way and easiest way is to say that an executive instrument is an instrument which has been fashioned by the executive and put before Parliament and passed.
Okay.
So that is an instrument that comes from the executive.
Precedents.
With the constitutional instrument, it is a matter which takes its validity and its strength from a provision in the Constitution. So pursuant to the provisions of the Constitution, the instrument is passed. Now, the legislative, as the suggestion is, comes from Parliament. So that instrument is made pursuant to whatever law, which gives Parliament the power to pass the law.
All right. I've got a lot of questions. It's interesting, really, but unfortunately, it means that it's going to truncate the rest of the procedure that we're going to take you through smoothly, how it starts and then to the end. This one says, Honorable Lawyer Tony Forsing, is the court going to declare a precedent or runoff? Which of these can be done by the court with regards to the law? Adamu in Damongo sent in that one.
Yes, Adamu, what happens is that a petitioner sends his petition to court and makes specific requests of the court. So he will lead evidence on the specific request, and the other parties will be given the opportunity to rebut it. If at the end of the day the court finds that the petitioner's case is the right thing, it will give the petitioner his request. If not, the case will be thrown out by the court.
All right. In district assembly elections, which court do you have to go to? This is from Japan in Odasco. District assembly elections.
I believe it's the High Court.
Exactly. Indeed, this is the kind of guest we want concerning issues like this, not members of political parties. We want to see you again, Mr. Tony Forsing. And is it wrong for the president to call 4,800 witnesses? This is Abubakar Adams in Zagun. Abubakar Adams, Zagun in Accra.
Well, if you look at the law states that you shall, the petitioner shall state his citizenship, how he acquired the citizenship, what he wants, supported by an affidavit, and the number of witnesses that he intends to call. Conversely, I believe that also applies to the respondent.
Okay.
Now, so there's no limit. As if you look at the law says that the number of witnesses. But today we're having a discussion, and the view was that in spite of the number of witnesses that you intend to call, I believe that the court itself would arrange its procedures to expedite the trial.
All right. Stanley Newman Mamata says, to me, I think the rule of law is really working, but I only hope this will not bring any unforgettable scenes to Ghanaians because the world is watching us. Doreen sent in this. She says that the election was free and fair, but just that Kufuor. All right, these are the text messages I won't take. Abdullahi Motaru says, in the case of election petition, are the judges supposed to deal with all matters or other cases related to the petition before the substantive case is dealt with, such as the one taken by Bernard Mona? I need further enlightenment. Bernard Mona's rate, automatically, will it be determined before the main petition brought by the petitioners, or what will happen?
I'm unable to tell. I believe that the honorable justices in the Supreme Court and the Chief Justice as head of administration know exactly what to do. I do not intend to express an opinion on that. Let us leave them to what they call case management, to do what will best suit our circumstances.
The suggestion is that, for example, he's challenging the CI 74 in respect of it saying that the decision of the Supreme Court in the presidential election petition is not subject to review. And then again, that it says that the court can sit on public holidays, including Saturdays and Sundays. This is contrary to the Public Holidays Act. And then not having a review, which means in the end, if the case is determined, a party which still feels aggrieved cannot appeal the matter. So some say, in that case, then maybe that matter should be dealt with first.
Well,
they will take that decision.
That decision will be taken. At least what Bernard Mona's writ seeks to do is to go according to what the Constitution says, that any person who thinks that any act is unconstitutional shall bring an application before the Supreme Court for a declaration to that effect. And what he has done is the right thing. And the honorable justices of the Supreme Court will make a determination one way or the other. And will come back, and whatever they say will also explain in layman's terms for everyone to appreciate.
Okay. I've been having a chat with Tony Forsing, who's the National Public Relations Officer of the Ghana Bar Association. And you've heard yesterday and today they have been in the news with a circular urging all the legal team members, the petitioners and the respondents to stop running commentary on radio. He has made a difference between what can be said, what cannot be said, who can say something about a matter pending in court and who cannot do that. The processes from day one up to a point where it ends. And that is where I'm going to close, draw the curtain on the discussion. The very final question to you is that, moving on, the case will start proper sometime very soon. When it does, how do you expect, what do you expect to be the posture of the totality of Ghanaians as the case, is heard?
I believe that keen interest must be given to the case. Your reporters must follow and report accurately what happens in court, what the parties say, what the judges say, for the people to know. Because as you said, for example, not everybody will get the accreditation to get into the court.
Exactly.
So, when you teach media law, it says fair and accurate reportage.
All right.
That is okay.
Thank you very much indeed, Mr. Tony Forsing. He is the Public Relations Officer National of the Ghana Bar Association, and he has been our guest on PM Express tonight. Thank you very much. I'm sure that you have been educated on some essential matters on election disputes resolution by the courts. In that matter, I would say election dispute adjudication. And thank you also for watching and for contributing by text, asking all your questions. On behalf of the rest of the production team, I say have a very good night.